Okay, we're in Chapter 9 of Criminal Law, Responsibility, Modifying Circumstances, and the Model Penal Code's being presented here on page 290, starting with Section 2.11, Consent. In general, the consent of the victim is In general, the consent of the victim to conduct charged to constitute an offense or to the result thereof is a defense if such consent negatives an element of the offense or precludes the infliction of the harm or evil sought to be prevented by the law defining the offense. 2. Consent to bodily harm. When conduct is charged to constitute an offense because it causes or threatens bodily harm, consent to such conduct or to the infliction of such bodily harm is a defense if A. the bodily harm consented to or threatened by the conduct consented to is not serious, or B. the conduct and the harm are reasonably foreseeable hazards of joint participation in any concerted activity of a kind not forbidden by law, or C. the consent establishes a justification for the conduct under Article 3 of the Code. 3. Ineffective consent. Unless otherwise provided by the Code or by the law defining the offense, assent does not constitute consent if A. it is given by a person who is legally incompetent to authorize the conduct charged to constitute the offense, or B. it is given by a person who, by reason of youth, mental disease, or defect, or intoxication, is manifestly unable or known by the actor to be unable to make a reasonable judgment as to the nature or harmfulness of the conduct charged to constitute the offense, or C. it is given by a person whose provident consent is sought to be prevented by the law defining the offense, or D. it is induced by force, duress, or deception of a kind sought to be prevented by the law defining the offense. Section 308 of the Model Penal Code is titled Use of Force by Persons with Special Responsibility for Care, Discipline, or Safety of Others. And so we're starting with the use of force upon or toward the person of another is justifiable if ... and we're starting with 4. The actor is a doctor or the therapist or a person assisting him at his direction, and A. the force is used for the purpose of administering a recognized form of treatment which the actor believes to be adapted to promoting the physical or mental health of the patient, and B. when treatment is administered with the consent of the patient, or if the patient is a minor or an incompetent person, with the consent of his parent or guardian, or other person legally competent to consent on his behalf, or the treatment is administered in an emergency when the actor believes that no one competent to consent can be consulted and that a reasonable person wishing to safeguard the welfare of the patient would consent, or ... we're skipping to section 213.1 of the Model Penal Code, rape and related offenses, ... starting with 2, gross sexual imposition. A male who has sexual intercourse with a female not his wife commits a felony of the 3rd degree if ... C, he knows that she is unaware that a sexual act is being committed upon her, or that she submits because she falsely supposes that he is her husband. Anyway, now we're moving on to Section 4, guilt of the injured party. Guilt of the injured party will be a complete defense as to acts which would otherwise be criminal if such acts were committed in self-defense or otherwise to prevent crime and did not exceed the privilege recognized by law for such a purpose. In such a case, the person has no wrongful purpose in mind, but in merely seeking to frustrate a crime attempted by another. On the other hand, it is an established principle of law that one crime is no excuse for another. The fact that the person killed was himself a murderer is no defense to a charge of murder. And it is just as much larceny to steal from a thief as to steal from anyone else. Although, needless to say, the recapture of stolen property from the thief by or for the lawful owner is not stealing. It is also larceny to steal liquor or drugs from one who violated the law by possessing it. And the fact that counterfeit coin was paid to a prostitute for unlawful intercourse is no defense to a charge of uttering counterfeit coin. Shall we go on reading United States v. Dykes, United States Court of Appeals, 9th Circuit, 2001. Memorandum opinion in brackets. Defendant Isabel Dykes appealed her conviction after a trial jury for blackmail, claiming that the conviction was not supported by sufficient evidence. We affirm. The French-American International School, FAIS, in San Francisco hired defendant, a British citizen, to teach mathematics. The school gave her the necessary paperwork to fill out so that she could obtain a J-1 visa. Shortly after defendant arrived in the United States, her relationship with her new employer began to deteriorate. FAIS decided to fire her. It wrote a letter terminating defendant's employment and advising her to return to England because her J-1 visa becomes null and void at this time. Defendant and her boyfriend responded with a long letter, which became the subject of the prosecution. The heading of defendant's letter said that it would detail, in quotations, the illegal methods systematically used by FAIS to damage those teachers hired from abroad. Emphasis in original. Defendant's letter referred to the illegal manner in which FAIS tried to harm defendant and the illegal extremes to which FAIS is prepared to go to achieve this. Quotations, emphasis in original. After describing the termination letter's discussion of the J-1 visa as a legally unjustified attempt to terrorize defendant into leaving the United States, defendant's letter continued, the fact, however, that you at FAIS readily abuse U.S. laws to illegally get rid of those teachers who refuse to be intimidated and forced into submission by you clearly exposes not only your trap and racket, but also what criminal elements you all are. As a first step, I will send this letter not just to the British and French consuls, SIC, in parentheses, and ambassadors and relevant authorities here, but also to all the newspapers and TV stations. I hope you are aware that the internet, of which I am knowledgeable, offers unlimited possibilities to make you and your school famous worldwide. The only way I can see for you and FAS to get off the hook is for you to provide Miss Dykes with an apology for your inferior behavior. However, since I know what crooks you are, your apology can be truthful only if you immediately pay Miss Dykes her full salary of $40,000 plus $20,000 for the damages you have caused her. You have her bank account number here in San Francisco, so deposit this money there at the latest by Friday at 14 o'clock. This opportunity given to you and FAS is neither negotiable or revocable. Underline, emphasis in original, italics added. The statute that defendant was convicted of violating provides, whoever, under a threat of informing or as a consideration for not informing against any violation of any law of the United States, demands or receives any money or other valuable thing, shall be fined under this title or imprisoned not more than 1 year or both. And that's under 18 of the United States Code, Section 873. The elements of the statute are simple. Under Section 873, a threat to expose a violation of federal law unless a thing of value is given is blackmail. A rational trier of fact could have found that defendant's letter threatened to inform the public and authorities of alleged violations for federal immigration laws if FAS did not pay defendant $60,000. That is all that Section 873 requires, affirms. And now we'll progress straight through to the conduct of the injured party. The rules of law and this is section 5 of chapter 9, the rules of law concerning negligence as a defense in civil actions for personal injuries have no application to criminal prosecutions. It is enough to say that contributory negligence, if shown, is never a defense or excuse for crime, nor can it in any degree serve to purge an act otherwise constituting a public offense if its criminal character. In one case, a man threw a handful of blasting powder into an open fireplace. A resulting explosion set fire to the building, and the wife of 19-year-old son of the host were burned to death. Several others, some of them younger and less able to take care of themselves than those who were killed, were able to get out of the house in safety. But this did not entitle the defendant to an instruction that he was excused if those who did not reach safety had failed to use due care in the effort. In another case, defendants had run over and killed a pedestrian while they were driving a horse and carriage at an excessive rate and were somewhat intoxicated. They thought they should be excused because deceased, who was deaf, had the habit of walking in the middle of the road at various times of day and night, but the court held otherwise. It does not follow, however, that the conduct of the injured party must be ignored. His conduct may have a bearing on whether or not the one who caused the injury was culpably negligent, or it may be found that the negligence of the injured party was the sole cause of the injury. If the decedents were negligent, says the Washington court, and such negligence was the sole cause of their death, then the appellant would not be guilty of manslaughter. Okay, so this is a short case demonstrating this section, conduct of the injured party, in the same manner that the Dykes case was a good demonstration of Section 4, guilt of injured party. So we read State of Monell, Court of Appeals of Minnesota from 1984. This is on page 924. Appellant Marion Munnell was charged with criminal vehicular operation in violation of Minnesota Statute Section 609-21, sub D1. At an omnibus hearing, she moved for dismissal, contending the statute is vague and overbroad, and that its failure to distinguish between drivers under the influence who are more or less negligent than the victims whose death they caused violates the Equal Protection Clause. The trial court denied both motions, but pursuant to min.r.crim.p Sect 28.03 certified 4 questions raised by the motions for consideration by the Court of Appeals. We affirm the trial court's position on all 4 questions certified. So the facts are as follows. Early on the morning of August 20th of 1983, Munnell was traveling south on Itasca County Highway number 39. She swerved across the yellow double center line and struck Kenneth Cloud, who was lying unconscious on the road. Her right front and rear tires ran over Cloud and killed him. Blood alcohol test showed that defendant had an alcohol concentration of 0.11%, and the victim had an alcohol concentration of at least 0.24%. In Minnesota. Issues. The trial court certified the following question for our consideration, ... Is being less at fault than the deceased victim a defense to the prosecution under Section 609.21 sub D1? Fault of defendant as a defense, considered by the court, reads as follows. Finally, the trial court properly refused to instruct the jury that fault of the victim is a defense to Minnesota Stat 609.21 sub D1. The Minnesota Supreme Court has repeatedly held that contributory negligence of the victim is not a defense in a criminal prosecution. Courts of other states have likewise rejected victim negligence as a defense in vehicular negligent homicide cases. However, victim's negligence is irrelevant on the question of whether the defendant was negligent, and if so, whether that negligence was the proximate cause of the victim's injuries. The decision, according to the rule, is constitutional both on its face and as applied to drivers under the influence less negligent than the victims whose death they caused. Fault of the victim is not a defense to the statute, affirmed and remanded for trial.